Prosecutors have just released the motive that they say was behind Alex Murdaugh killing his wife and his son. So we're going to jump right into that document. If you don't recall, Alex Murdaugh was an attorney down in South Carolina who apparently stole a whole bunch of money from his clients and his law firm, tried to make his wife and his son's death look like somebody else did it, then tried to make it look like he got shot so his other son could get the insurance money or something like that. But let's go ahead and dig into this document. South Carolina, this is the state's response in opposition to defendant's request, defendant's motion for a bill of particulars and state's motion to admit evidence of motive. Now, I'm not really going to talk about the bill of particulars here. That just means they're asking for more information regarding his charges. So we're going to scroll down here. Full name, Richard Alexander Murdaugh. And I think this starts on page 6. I have not read it yet, so we're going to go through this together to see what the state is saying, even though most of us have an idea of what was going on at this point, right? We are going to start on page 11 down here under C. Generally, the evidence sought to be admitted. In the present case, Murdaugh's motive for committing the murders is an issue of obvious importance. In addition to the general significance evidence of motive can have in any murder trial, Murdaugh has been charged with murdering his wife and son, and my battery is sort of dying, so let me plug that in. 2 integral members of his own immediate family. Yes, he killed his wife and his son, allegedly. Since people are naturally expected to love their wives and sons, instead of brutally gunning them down, why Murdaugh did what he is accused of doing will unquestionably weigh on any rational juror's mind when deciding whether the state met its burden of proof. Therefore, any evidence bearing on Murdaugh's motive for the killings has heightened probative value in his case under the circumstances involved. Beyond that, Murdaugh himself placed the issue of motive front and center through his own actions, demonstrating that fact. Murdaugh, within just over 30 seconds of beginning to speak to the first officer to arrive at the scene on June 7th, 2021, suggested to law enforcement that the killer's motive stemmed from the February 2019 boat wreck that resulted in the tragic death of Mallory Beach. In fact, Murdaugh expressly expressed certainty and stated he knew that's what it is, the boat case, to the responding officer. Thus, based on his own statements, Murdaugh placed motive into issue from the outset of law enforcement's investigation into the killings, and he tried to tie that motive to events that had occurred more than 2 years earlier. Now, if you recall, Mallory Beach was one of the teenagers who was in the boat when Murdaugh's son, who had been drinking, crashed the boat, and several teenagers were thrown from the boat and injured as a result. So Mallory Beach is one of the people who was in that crash. And so they're saying that this is possibly a motive here. Looking at FedEx drop something off at my neighbor's house. Yes, I am that nosy neighbor. All right, let's get back to the facts here. All right, thus, based on his own statements, Murdaugh placed motive into the issue from the onset and 2 years later. Okay, significantly, based on the evidence that has been uncovered during the investigation into the killings, Murdaugh was the only individual with a true motive to kill his wife and son. As to that motive, the evidence will show Murdaugh accrued substantial debts over a period of years, and to cover those debts, began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own law firm. The evidence will further show these financial crimes were about to come to light at the time of the killings. More specifically, on the date of the killings, personnel at Murdaugh's law firm had demanded Murdaugh provide an explanation no later than that day as to where hundreds of thousands of dollars in legal fees owed to the firm but stolen by Murdaugh had gone, and Murdaugh had neither the money nor a plausible legal explanation with which to respond to the demand. Meanwhile, a motion to compel the production of Murdaugh's personal financial records was at the same time pending in civil litigation stemming from the fatal boat wreck. And a hearing on that motion was going to be held within a few days. So let's stop there for a second and see where we are, because at this point, this speaks to the timeline and how, these things, like this is happening this day. The lawsuit related to Mallory Beach's death, they are asking for financial records. His law firm is saying, hey, by the end of the day, you need to tell us what has gone on with this money that belonged to the firm, that belonged to the clients, whatever that is. And the prosecution is saying that all of this was happening at that moment. And that is why the killings were done then, not some other time. But they're saying this speaks directly to his motive at that particular time. Let's see. If granted, as expected, that motion would have resulted in the exposure of Murdaugh's financial records, which would itself have led to his misdeeds becoming known to others. Well, why does that matter? Because they were this prominent family. When you have this legacy, this history, and you're in this community and everybody knows you, then you don't want to mess that up. You feel like you've got to live up to all of these expectations. That is the position that he was in. All of this was about to be known to others. That's what the prosecution is saying here. Ultimately, the murders served as Murdaugh's mean to shift the focus away from himself and buy himself some additional time to try and prevent his financial crimes from being uncovered, which, if revealed, would have resulted in personal, legal, and financial ruin for Murdaugh. And it absolutely worked until a PMPED staffer came across a check on September 2nd, 2022, which started the process of unraveling the whole thing. Now, I sort of disagree with the statement that says he might have gotten away unless this one check. I don't think so. At some point in time, you're going through your trust account records. You're going to figure out what's going on. Most state bars have a process that says you have to reconcile at least a certain amount of time. So it could be that the firm has to reconcile at least quarterly or maybe even monthly. And then if they're doing that reconciliation, they're going to realize some money is not there. If also the state comes in and does its own audit, or whatever the local bar or whoever the auditing party is, as some states have, it could have gotten found out that way. So this check may have been the thing that instigated it then, that started it then, but I think it was going to come to light. You just don't go missing those amounts of funds these days. It's just too easily to track that. I think people would have found out at some point in time. The check just made it happen faster, is what it really, really sounds like here. So started the process of unraveling the whole thing. In finer detail, the state intends to prove the following at trial. Defendant came from a family of a singular position of prominence and respect in the community. He had, however, been able to avoid accountability throughout his life, while outwardly giving the illusion of financial wealth from his lucrative law practice. A series of bad land deals, exacerbated by the recession, permanently changed his finances. While some thought defendant had recovered with some large cases in the early part of 2011 through 2015, such as the Thomas Pickney, Plyler, and Badger cases, defendant had become so dependent on a constant velocity of money to service his huge debt and maintain his lifestyle that even the millions in fees were not enough. So it's interesting how they categorize this as the recession permanently changed his finances. I don't know if I all the way agree with that, because maybe you can, change your lifestyle and change some things. It's just that maybe they didn't want to because they led a lifestyle of prominence, and it would show people that they weren't as maybe successful as they wanted people to think that they were. This sort of pride thing is, what will do us in sometimes. And this sort of thinking that we've got to continue this facade of looking like everything is okay. instead of just saying, you know what, the economy killed me. It killed me. We are literally going to have to start back over at zero. We may have to file for bankruptcy. We might have to do Chapter 11 reorg, or we might just have to, hey, here's what can stay, here's what can go. Well, we may have, we may have to do Chapter 7, and there's not a whole lot there. We may have to do Chapter 13, where we can reorganize some of our debt and just make monthly payments. Sorry, I was talking so fast, but you guys know the difference between Chapter 13 and Chapter 7. Okay, Chapter 13, you got a plan. Chapter 7, you're pretty done because there's not a whole lot there. And I'm making that sound a lot simpler than it is. It is way more complex than that. So they were stating that his position had changed permanently. It says, in addition to borrowing from anyone who would lend money to him, from banks to family to his partners, defendant also started to allegedly steal money from clients, his firm, and his family in order to keep his head above water. So let me just sort of backtrack here for just a second, because remember, it started off here saying that he had, however, been able to avoid accountability throughout his life. I really thought they were going to go into more detail there and talk about some of the ways in which he hadn't had to take accountability for some of his mishaps. But so far, it just sounds like they're really just talking about the lifestyle that he's in right now. Defendant allegedly stole through four main schemes. First, he stole by billing personal expenses to his clients and on firm credit cards or accounts. Second, he stole from his own family and the firm by, in one instance, taking a six-figure loan repayment check he knew had been erroneously issued to him, claiming he lost that check and getting another one issued, depositing the second check, and then waiting months to deposit the first, thus stealing the same money twice. I don't really understand how you think you can get away with that, because whoever is giving you the money is going to then see that both checks have been deposited. They're going to then check with their financial institution to say, where were those funds deposited? You're going to see if the check was endorsed. You're going to see the signature. So there is a tracking mechanism there. So to some extent, you wonder if he was even really thinking this through. It's like, you're trying to be a criminal, but you're not even really good at it. And it's almost like you should have just stuck to practicing law. You were good at that, but the whole criminal thing is just not working out for you. You are doing a bang up job of this. So I don't know how he really thought that that was not going to be found out. There's just too much tracking that's going on now. There's no way you can really get around that. The third scheme, through which defendant allegedly stole client funds, was by having PMPED client trust account disbursement checks made out to Palmetto State Bank. He then would have Palmetto State Bank executive Russell Lafitte, who just had his own trial, convert those client checks to defendant's personal use for such things as paying off clients' debts to defendant's father, and to PSB. Defendant and Russell Lafitte, and I'm not sure if it's saying his name right. I hope I'm getting it right. Also used allegedly stolen client money to pay off almost $1 million in loans Russell Lafitte had loaned from his conservatorship over Murdaugh's clients, the Plyler girls, in order to keep defendant afloat. Defendant would either have Russell Lafitte as a conservator or personal representative sign the client disbursement accounting in which the funds to be sent to PSB were listed among other funds. Haha. So fake invoice almost. Or defendant would convince clients nothing was amiss on the disbursement accounting while they were focused on the substantial funds they were receiving and not noticing something as innocuous looking on its face as a disbursement to Palmetto Bank. So here's the thing. I know people like to give others the benefit of the doubt, and it's not just attorneys. If you think about it, you have heard of celebrities, you have heard of athletes having managers, having financial planners, having accountants in place who are supposedly looking after their best financial interests. They are the ones who are maybe signing checks. They're the ones who are maybe receiving monthly bank statements, and they're reviewing these things. And as the client, celebrity slash entertainer slash athlete, you think these people are looking out for you because they're supposed to be professional. They're supposed to have a fiduciary duty to you and look after your best interests. And then there's this whole sort of, you don't want to question this professional because this professional is a professional. They're educated, they have expertise in these areas, and typically you do not. So you tend to have some hesitancy, especially if you don't have the educational level that they have, and you look at it and you go, well, Palmetto State Bank sounds legitimate. I have seen them down the street, or I've seen them, on the web or in the news or wherever. And so you're not thinking that there's anything wrong with a line, on the list of disbursements that has Palmetto State Bank there. And so you say nothing, you're still getting your checks. You have no reason to think that there's anything going wrong there. The Forge scheme through which defendant allegedly stole client funds was through the fake Forge account, which he opened at Bank of America in 2015 under the name Richard A. Murdaugh, DBA Forge. Forge Consulting LLC was a legitimate company used by plaintiffs' lawyers as a consultant to match clients receiving large settlements with annuity companies. Once defendant was able to open an account with Forge's name on it, he could have client funds dispersed from the PMPED trust account on a check made out to Forge. Like checks made out to PSB, entries on the disbursement sheet to the no-name Forge did not attract staff or client attention, particularly when the clients were diverted by the large sums they were receiving from the legitimate entries on the disbursement accounting. Y'all, they were just like, the money's coming in, it looks good, everything's fine. And so they really did not dig through and say, hey, explain to me what these disbursements are for. You got to ask questions. That's all I can say. I know it's difficult sometimes. During this time, that defendant was allegedly stealing millions from clients, despite also earning millions in reported income from his law practice. So he's rolling in the dough. Defendant was also borrowing millions from wherever and whomever he could. I'm always fascinated by people who have money and they're able to get more money more easily than people who are struggling and really need money for just the basics of living and everyday expenses. The evidence will show defendant bounced between massive interest payments and inadequate principal payments and consistently carried staggering six-figure balances on multiple debts, including lines of credit and even a credit card. He borrowed nearly $1 million from one law partner over a period of years, as well as hundreds of thousands from his father and from Russell Lafitte's father. All of the millions of dollars coming to defendant from legitimate income to stolen client funds to large loans and credit cards still was not enough to stop the incessant financial roller coaster in which defendant put himself. Things only got worse on February 23rd, 2019, when the boat crash happened, resulting in the death of Mallory Beach. Not only was Paul facing very serious criminal liability and the possibility of 25 or more years in prison, defendant and his family were now facing significant civil liability for the events leading to Mallory's death, with the Beach family filing a civil lawsuit filed against defendant and his son Buster on May 24, 2019. The plaintiff's attorney in the civil boat case made it clear they were seeking nothing less than an aggressive monetary recovery from defendant's personal assets. And why do you think that was the case? If the party who is at fault doesn't have deep pockets, a lot of times an attorney's not going to go after them aggressively because there's nothing to get. In other words, you're looking to make sure if they do get something, you can get it, or you're looking to make a statement to say, hey, you did it, and not only are you criminally liable, but we are going to show through a jury that here's what the monetary number looks like, because that is what it was worth in terms of what you did, the harm that you caused. Ow, that doesn't really happen if somebody, is not of substantial wealth. So here's the thing, the fact that he had this facade of being wealthy, of coming from a prominent family, of having assets, that people, could see. Had he filed for bankruptcy, had he actually not had that facade, they might not have gone after him as hard as they did. But they presented a certain image, and so you present this image that you have all of this, and so then it becomes, well, if you're civilly liable, you're going to need to either sell some of that, or do something in order to pay the civil liability that may come from that. But it may have been different had he not shown to the world that he was still a person of substantial means, that he and his family were still people of substantial wealth. It says, tellingly, the aftermath of the boat case also saw a large uptick in the amount of funds defendants started to allegedly steal, including over 3 million from the Satterfield recovery and about 4.5 million total from clients during January 2019 until April 2021 alone. The boat case also marked a large uptick in the checks defendant had been writing to various associates such as Curtis Eddie Smith. While some of this money was for narcotic pills, the pace for Eddie alone increased to over 1 million alone in 2021. The amounts of the individual checks increased as well. Okay, so I didn't know that there was a drug piece to this until I actually opened this up and started looking at this today. Defendant had one possible saving grace in a plaintiff's case defendant was sharing with Chris Wilson. The decision from a bench trial was issued in February of 2021, and it resulted in fees of $792,000 to defendant, $600,000 for one case and $192,000 for the other. However, defendant convinced Chris Wilson to make the checks for the fees out to him personally instead of to PMPED as it should have been. Defendant deposited those checks into his personal account in March and April of 2021, thus ensuring that he could get to the money right then and stay afloat, as opposed to having to wait till the end of the year for PMPD to disperse fees as part of his bonus. The windfall of over $750,000 only provided a brief respite from the pressures that continued to mount on defendant, and it was quickly spent. I wish they would give a little bit more insight into what quickly spent means. And I'm sure once they start the trial, and they may still be on target for the next month or two, once they start the trial, that they will break down all of those expenses and what they look like, and actually show money coming in and showing it going right back out and what it was going out for, because then you paint a much stronger picture that he was really in need of those funds. And that's why he took them right then. And that's why he took them the way that he did. So all of those things will really matter. So it'll be interesting to see to what extent the prosecution presents some of those details during the trial. Defendant's civil attorneys had finally told the plaintiff's attorney in the boat case that defendant had no money to personally pay any settlement. Aha! Incredulous and still believing he was very wealthy, the plaintiff's attorneys filed a motion to compel on October 16, 2020, demanding defendant disclose his bank accounts, assets, and finances. If that motion was granted, as was expected, the true picture of defendant's finances and his years of alleged theft would be quickly exposed. The hearing was initially scheduled for May of 2021, but was continued to June 10th, 2021. Meanwhile, in May of 2021, staff at PMPED had become suspicious when they noticed that they had received the expense check from the case defendant had with Chris Wilson, but had not received the fee check. Their inquiries to Wilson's office did not get to the bottom of the matter, and they could not get a satisfactory answer from defendant as to where those fees went. The problem was discussed with partners at PMPED, and they worried that defendant was trying to hide income because of the boat case. So by now, the firm is, they have some awareness that there's something going on. On top of this, in March, April, and May of 2021, state grand jury subpoenas about the boat case were issued for testimony or documents to various witnesses and institutions with a connection or presence in Hampton and the 14th Circuit. All of these factors started to converge on June 7, 2021. On June 7, 2021, defendant's finances were falling apart. He did not have enough to pay back Chris Wilson to cover up the fact that he had bypassed the firm of $792,000 in fees. On June 7th, 2020, defendant was in the office working on the disclosures in the boat case because a hearing on the motion to compel discovery of defendant's finances was scheduled for June 10th, 2021, just a few days later. Okay, so a hearing is scheduled June 10th, 2021. Disclosure of the finances would expose defendant for his years of alleged misdeeds. There would be no continuance this time. So typically, if there's a hearing and a party is not prepared, usually a judge is receptive to providing at least one continuance, providing that you can show a reason why, and providing that the other party is, if the other party agrees, you're good to go. If the other party doesn't agree, you need to be able to say, come up with some really good reasons why. All right. So June 7th, 2021, a PMPED staffer came into defendant's office and demanded an answer that day as to where the bypassed fees were. However, on June 7th, defendant had already spent the fees and could not pay them back to cover his track. Who has $792,000 just lying around? On June 7th, 2021, defendant received word that his father had been taken to the hospital with a very poor prognosis. Defendant's father had previously loaned defendant money or co-signed for defendant. So all of this stuff's just going on June 7th, okay? June 7th, 2021, defendant murdered Maggie and Paul. Immediately, everything changed. People immediately treated defendant as the victim of an unspeakable tragedy. Everyone backed off their inquiries and rallied around him. The PMPED partners and staff were no longer seeking immediate answers about the bypass fees and stopped making inquiries. The hearing on the motion to compel was canceled, and a personal recovery against defendant in the civil case was in jeopardy as a practical matter. The day of reckoning vanished. In the aftermath, the murders gave him, defendant set about covering his tracks. He borrowed money to cover enough of the bypass fees so that Chris Wilson could send them to PMPED as if they had been there all along. He borrowed from a law partner and continued to write checks to Eddie Smith at an accelerated rate. So this is where some of the money is going, okay? It might have worked, but for the fact that on September 2nd, 2021, staff at PMPED discovered in defendant's office a copy of one of the fee checks Chris Wilson had written to defendant directly. It was taken to PMPED finance office, where it triggered staff there to take a closer look at one of the forged matters that had taken a back seat in the wake of the murders. Some more research was done. Partners were called with the findings on September 3rd, 2021. Defendant was ultimately confronted with the discoveries of his misdeeds and resigned. On September 4th, 2021, Chris Wilson finally was able to get defendant to meet with him to discuss the resignation and the $192,000 defendant owed Wilson for covering the shortfall in the payment of the bypass fees to PMPED. Within hours of defendant meeting with the friend he betrayed on the front porch of defendant's mother's house, as accountability started to fall on Alex Murdaugh again, defendant suddenly became the victim of a shooting on the side of the road in Salkehatchie. I guess that's how you pronounce that. People initially rallied to his aid again, only this time facts came to light a lot quicker. So you may remember this, the whole shooting that supposedly took place on the side of the road. All right. So then they've got some other information here about rules of evidence, but that is primarily the motive that they are talking about. Let's head to the conclusion here. They say this case is unique in South Carolina history for many reasons. One of those is that exposing what happened to Maggie and Paul necessarily has its roots in a corruption that began years ago and festered until June 7th was the result. The evidence should be admitted so that the jury can fairly assess why a man might murder his wife and son. All right, there you go. There you have it. That's the conclusion. So they have done a very good job of putting a timeline together and then tying facts related to Murdaugh and the killings, what was going on with the firm, so that everything tracks together, so that it's easy. It's going to be easy for a jury to sort of see those come together, and why in the end you had this ultimate murder of the wife and the son. So this is such a tragedy. But, had he made different choices, one of the things that probably could be talked about a little bit more would be not just the role, because I mentioned this before, not just the role of, a prominent, wealthy Southern white family having to live up to expectations in its community, but what was the role too of drug use in here? They talk a little bit about it, but they don't go into detail, and I do not expect them to go into detail there, because then it clouds their the story that they are putting together to give to the jury. The piece about the drug use, we're probably going to see more of that come from the defense. They may use that as a way to say that he was not thinking clearly. And they may have already said some of that. I may just not have seen that. But I expect that to be one of those things that the defense spends a little bit more time talking about. The prosecution is focusing on getting their timeline straight, making sure they have the facts, making sure that all of these financial documents show exactly what they need for them to show, and then getting their witness list together so that all of these people can talk about the documents and the conversations that they had with him during this timeline that led up to the ultimate event. So that's it. We now know Murdaugh motive finally revealed. Don't forget to like the video, subscribe to the channel. Peace.